Hi, good morning, folks. This is Rajiv S. Khanna for Immigration.com, Law Office of Rajiv S. Khanna, PC. This is a continuation of a community conference call in which we specifically wanted to discuss AC21 issues because there's a bunch of them that bear recording in a separate treatment because a lot of people face the same kind of issues and there's a lot of doubt about how to handle them. I have with me two members of our community on the phone. I have Uday and I have Goyal. I'll start with Uday first because he logged in the first. I just want to take his questions. Now, it's clearly understood this call is being recorded. It will be made publicly available, and everybody's fine with it. Okay, that said, Uday, I also want to confirm for the record this is just an information call. You are not hiring us. We are not agreeing to represent you. Neither party owes the other anything. Okay? So with that said, Uday, go ahead with your questions. Let's start.
Okay, thanks, Rajiv. I will read the question which I posted, which is, Company A applied for my labor I-140, 485, and everything went through, and I got my EAD through the Company A.
Uday, one second. I have the question in front of me. You don't have to read it.
Yeah,
so Company A applied for labor in I-140 and 45. You got the EAD through that company in EB3. You switched to Company B invoking AC21, where you're working for the last 2 years. Okay. Company C applied for future employment. Company C applied for future employment. Okay. First thing I want to make clear for everybody is that under Yates Memorandum of May 2005, it is absolutely okay for you to do an AC21 based upon a future company's job application. So let's modify your example a little bit. Let's say you are working for employer B and employer C has started your green card as a future employment. Let's say an employer C gets your I-140 approved. Can you now file 485 through employer C even though you're working for employer B? And the answer is yes, of course, based upon a genuine desire to join them, employer C, when the green card comes through or sometime before that. Can you, after 180 days, without ever joining employer C, join an employer D or continue working with employer B? Yes. You can do an AC21 without ever joining the future employer. Okay? There has been some confusion about this issue. But Yates Memorandum does say that very clearly. This is a memorandum from May 2005. Okay? It very clearly says it is okay for you to port from a future job without ever joining that employer. So, as a principle, that's clearly understood. Now, looking at your situation specifically, green card EB3 started with employer A, moved over to employer B, green card, and you're on AC21, and green card done through employer C under EB2 category from an earlier date. So your EB3 date is 2006, but your EB2 through Company C is 2004. Am I right so far?
That's right, Raju.
Okay. Now, to make things kind of interesting, Company C got closed. So that company is no longer in operation. Now, again, as a matter of general law, what happens is, a couple of things are clear. USCIS has the right to revoke an I-140, any I-140, where the company who sponsored that I-140 ceases to do business. How does that correlate with AC21? It correlates as follows. If somebody, an employee, has already used AC21 and ported using that AC21, and then USCIS revokes that I-140 for the company having ceased to do business, I don't think AC21 is going to get affected. You see my point? Normally, if you stayed with the same company, Company C, or you did not do a porting off of Company C's I-140 approval and 485 pendency, you would be out of luck because they can revoke the I-140 as soon as the company stops doing business. But in your case, they have not revoked. So the I-140 is still very much alive. However, what you cannot do is you cannot file a 485 based upon Company C's job offer because the company no longer exists. You could say, wait, Rajiv, I already have a 485 pending. You do. This is a gray area of the law that nobody can really answer for you. In your situation, can you use the future AC21 portability so that you can get EB2 date of 2004 with any employer? I'm not sure about that. But one thing I'm sure about is that you can get the 2004 priority date and take it to any employer. So what are you doing? You're doing a mixed thing. This is very sure. This you can do, at least so far what USCIS has said. This is what it says. Even if the I-140 is revoked, it's not revoked, but even if it were to be revoked, that 2004 date is yours to keep. So you are getting the date from employer C, but you're getting AC21 from employer A. So we know very clearly that you are entitled to EB3 2004. Am I clear so far?
Yep.
So you are entitled to EB3 2004, no question. Are you also entitled to EB2 2004? That's very doubtful. Why? Because even though the 485 that was pending does not have to be refiled when you file an EB2-based case through employer C for 485. However, if the company had still been in existence and you came to me and say, Rajiv, I want to get EB2, my 485 converted to an EB2 application, basically attach it to the I-140 through company C, I would have said, yeah, let's get an offer of employment from employer C and we can send that in. You see my point? I would have taken that and I would have told the government to convert your pending 485 to a petition of EB2 under company C. But the problem is that company is no longer in existence. Is that a required step? Not really. Sending a letter in from company C, is that a required step for converting your case to EB2 2004 AC21? Not really, but I think it can be said that it is. So we are clear you are entitled to EB3 2004 date because of company C's I-140 approval from 2004, but it is unclear whether you are entitled to EB2 2004. Are you clear so far, or am I making your head spin?
Yeah, no, yes, that is very clear, Raju. So my question is, this category, right, as you said, I was reading so many in the internet, so many articles, but nowhere they said this cannot be, the category cannot be ported or something. Nowhere, neither they accepted nor denied. I did not find anywhere which says accepted or...
Wait. Category cannot be ported. Explain that to me. I don't understand what that means.
Oh, okay. So, okay. The EB2, right, in this kind of scenario, can I, as you said, the date can be ported, but EB2, can it be ported to my company A? I did not find any article.
The only way, what you are saying is, can I port my EB2 job to my current company?
Okay, I think so. Maybe
there's no other way to port. You can either take the priority date, or you can take the whole green card. When you take the whole green card,
then
right.
With your terminology, whole green card, let me see.
Yeah, you cannot move that. We're not clear if you can move that because we don't have that one step of the job offer being submitted to USCIS.
Okay.
So had the company been in existence, and I could have gotten a genuine job offer from them, and I could have submitted that, then you could have ported that job anywhere, or that green card anywhere, including to your current employer. Okay. Now, can you do it anyway? I don't know the answer to that question because that is a gray area of the law. Nobody can, at least I don't think anybody can authoritatively say this is the way it's going to go. Is it worth trying? I don't know the answer. How far are you from your priority date in 2004 EB3? Is that too far away?
EB3 is as I posted, it is to November 2006.
No. I'm saying right now, what is going on in EB3 India based?
Oh, it is August 2002 or somewhere.
Oh, okay. It might be worth trying an EB2 AC21, but here is what you got to be careful with. And I think this is what we talked about yesterday. When you port a job, from one place to another, from one employer to another, what you are telling the government is this job is same or similar to the job that was the subject of the green card proceeding. So when you went from employer A to employer B, you told the government that, Mr. USCIS, the job that employer B is giving me is same or similar to the job that the employer A gave me under the green card.
Oh, yep.
Same or similar. Now, when you do an AC21 portability under the EB2, you will be making the same argument for the EB2 job. You'll be saying, Mr. USCIS, Company B is offering me a job that is same or similar to the job described by Company C in their green card petition. Now, I think we discussed this. You mentioned that briefly to me. You said that the two jobs are basically similar.
That is right.
I want a lawyer to look at it and make sure they are similar. That's the only thing I'm concerned about. I don't want you to push for EB2 and then have questions raised about your EB3 also. I think you are reasonably safe if the jobs are same or similar. Because for the same job description, one company can have one requirement, another company can have another requirements. We care only that the jobs are same or similar. Now this itself is a big problem. I want to make a general comment about this. Nobody quite knows what same or similar is. Okay? USCIS did a whole shebang of trying to clarify this, and actually they have not clarified anything. They've only made things more confusing. It appears that if the salaries are too far different, they can start questioning it. It appears that if the jobs are totally dissimilar, of course they are going to not allow AC21. But what is similar, nobody knows. So let your lawyers take a look at it. You don't want to take a chance with this. AC21 is a one-shot deal. If the 485 gets denied, we'll have a lot of problems. The only option at that point would be to get another job and try to reopen the 485, which becomes very complicated. Okay? So somebody should look at the job, make sure that the AC21 is applicable to the EB2 job without hurting your EB3. Okay? That's the only thing I would recommend. Anything else you have for me?
Yeah. Quickly, Rajiv, you were using AC21 portability only from the beginning, so is it not same as 485 filing for through company C? So what is the difference between these two?
So your question is, let me understand this. In general, not just for your case, in general, what is the difference between filing 485 through a future employer and just doing portability through a future employer, correct?
That is right, because you are only using the terminology AC21 portability here.
Let me explain to you. Let me explain to you what the difference is. Normally, in order for you to do portability, you have to file a 485. And the 485 must have been pending 180 days. And the I-140 must have been approved. What are we clear about? We are clear about the timing of the I-140 in general. I'm not talking about your question specifically, in general. We know if an I-140 is filed in January and an I-485 is also filed in January at the same time concurrently, the I-140 gets approved in July, which is more than 180 days later. Can you port now? The answer is yes, because the moment the I-140 is approved, we look back and see has the 485 been pending 180 days. If the I-140 is not approved, then you can't port. Well, no, let me rephrase that. If the I-140 gets denied, then you can't port. Okay? So we know that once an I-140 has been pending 180 days, whether or not it was after the I-140 approval, we don't care. Are you clear on that?
Yep.
Okay. Now, let's take your case specifically. You asked me, what is the difference, Rajiv, between I-485 filing and AC21 filing? In normal cases, in order to take advantage of AC21, you have to file the 485, have the 485 pending 180 days, have the I-140 approved. And does it have to be an I-485 with the same employer from whom the I-140 got approved? That's where the problem is. I don't think it does. You have a 485 pending, and you have an I-140 approved through employer C. Do they have to be in the same package? I don't think they do. Okay? But the grayness in the situation comes because we don't have an offer letter that connects anything to anything. So even though the I-140 was approved, the company sort of went out of business. Now, can we really do an AC21? I don't know. It's a gray area. I would push for it. I would try it, and maybe I can make USCIS see how technically this is okay. But I don't know for sure if it's going to work. Okay?
Okay. Yep.
Are you clear now?
Yeah, absolutely. Yep.
All right.
Thanks a lot, Raju.
Very good. You're welcome. You can hang up or you can stay on. It's up to you. Mr. Goyal, go ahead. It's your chance now.
Hi. Actually, my questions will start a little before, I would say, AC21, let's say, with first question on H1B. So let's say, for my background, I'm completing my 6 years on H1B in this September, and I have I-140 approved from my employer, and they have filed for my H1B extension, right?
Okay.
So, but I think the industry I'm working in is going through some tough times, and there may be some cuts coming in this, basically through my employer also maybe. So I'm just worried, so my first question is, if a person gets laid off on H1B, so is there any grace period that is he has to find the next job then, or?
There is no grace period, not even a day. And I have a very lengthy set of articles on my blog as well as question and answers on this issue. So I think if you just go do an advanced search on my blog and look for the words laid off, you will find it.
Oh, okay. Sure. And I think then that must most probably be also covering if the employer says I'll hold the H1 for 3 months or some time and generate pay stubs also.
It doesn't work. Unless they are paying you your full salary, it doesn't work.
Oh, okay. So if they're paying you full salary and generating pay stubs for 3 months.
Let me stop you there for 1 second, sir.
Yeah.
Have one thing very clearly understood in your mind. Mm-hmm. Merely generating pay stubs without actually paying you is not good enough. That's fraud. You don't want any part of that. Okay? Mm-hmm. A lot of employers will say, well, not a lot, but some employers don't understand the difference, and they think that this is perfectly okay. It's not.
Oh, okay. Sure. So my next question is, let's say, so I just read my 140 is approved, and I'm completing the 6 years in September. So if I find a new job, let's say that the next employer does the H1B, and as you told me yesterday that I can get the 3 years extension based on the I-140 approval. So does the new job have to be similar in role that I have now?
That's a very interesting question, and the answer is, luckily for you, no. You see, there are several benefits flowing from I-140 approval. Let me clarify them. There are several benefits flowing from I-140 approval. Benefit number 1, you get to carry your priority date forward. When you carry your priority date forward, does it have to be in a same or similar profession or job as described in the green card? No, it does not. To carry the priority date forward, it can be a totally different job, and it can be carried across categories. EB1, EB2, EB3 doesn't matter. Okay? So one benefit is priority date carry forward. Second benefit is AC21 if 485 has been pending. Then you have to have a same or similar job. Third benefit is H1 extensions. For H1 extensions, an approved I-140 must exist and continue to exist when you get the H1 approval. Okay? And the approval of the H1 does not have to be in the same or similar job for which the I-140 was approved. It can be totally different. It can be different job location, different region, different employer, different job. The benefit of H1 extension beyond 6 years does not require that your job must be same or similar.
Oh, okay. Sure.
Okay? So 3 different things. I-140 priority date and H1 extension does not require same or similar. Only AC21 job portability requires same or similar.
Oh, okay. That's good to know. Thanks. And so if I basically, the next question would be if I have to go, let's H4 for some time, and then I find a job, then can I use the same, and let's say my company doesn't revoke I-140, so can I use that I-140 to get like a 3-year extension on the new employer if I find them later on?
Theoretically, the answer is yes. But practically, this is what I would worry about. What I would worry about is, again, I don't mean to spook you or scare you, but it's a good idea to think of everything that can go wrong and kind of be ready for
Yes.
it.
Mm-hmm.
Okay? Here, there are cases on the books. I've seen them, I've read them, that say for an I-140 to continue to be valid, the job must not have been extinguished. The job must not have been extinguished. Okay? So, what if you file the H-1 and USCIS says, haha, you're an H-4. That must really mean that the job is extinguished, the I-140 job. So we're going to revoke the I-140.
Oh, okay.
Okay? Now, wait, it's very unlikely they'll do that. Extremely unlikely, but it can be said that it's possible. It may not be probable, but it's possible. Here would be my argument, and I haven't looked at the law very carefully from that perspective. My argument would be, as long as the I-140 was surviving on the date I filed the H-1, you have to give me my H-1.
Mm-hmm.
Okay? So, in short, I think you can, but be aware that there could be a slight issue, so, don't just say that it's already done.
Sure. Mm-hmm. I see. And I think my last question is, so let's say if I find a new employer and as is told, like I can get a 3-year extension based on current I-140 approval, so does my new employer have to start my green card process immediately, or since I have 3 years with him, he can start like after 1 year also?
They should start as early as possible. But normally, USCIS, once they have given the H-1, they will not take it back even if the I-140 is revoked.
Oh, okay.
Normally. Okay. So I feel that it will be reasonably safe for you to wait a year.
I see.
Okay. Anything else? Yeah, go ahead.
Sorry. And as I said, priority date can be carried over without any problems.
Absolutely. Because that USCIS made clear, even if we revoke the I-140, we'll let you carry the priority date forward.
Sure. I think these were my questions. And just a quick thing, actually, if you want to answer on this, like, are you a member of Hayat Legal Plan?
Oh, no, sir. I am not a member of any legal plan. Because, look, most of these legal plans pay very little. Most lawyers can't survive on that money. So,
sure. No, I can understand that, yeah.
We've been approached many times. We're not a member of any legal plan.
Sure, I can understand that, yeah. Thanks, Rajiv.
My pleasure. Good luck, guys. Thank you for being here.
Thanks.